Court is now in session. Please be seated.
Good afternoon, everyone. Introductions, please.
Please the court. Blake Rohrbacher, Richards, Layton, and Finger for appellees McDaniel, McInerney, and Samon. Also for those appellees, Maeve O'Connor from Debevoise and Plimpton, and Susan Giddies from Debevoise and Plimpton. With the court's permission, Ms. O'Connor will make the presentation. I will also introduce David Ross from Ross, Aronstam, and Moritz.
Never heard of him.
Joshua Hamilton from Latham and Watkins for appellees IAC Interactive, Dubay, Ginsberg, Spoon, and Match Group.
Good. Well done. That's a lot of names to remember.
Good afternoon, Chief Justice, members of the court. May it please the court, John DiTomo, Morris Nichols, Arsht, and Tunnel, on behalf of the IAC appellees, Messrs. Diller, Stein, Orlinsky, Schiffman, and Levine, also IAC Holdings. And with me at counsel's table are my colleagues from Wachtell Lipton, Ted Mervis, and Alexander Sadinsky. With your honor's permission, Mr. Mervis will be making presentation on behalf of the IAC parties.
Welcome.
Good afternoon, Your Honor. Kevin Davenport with Prickett, Jones, and Elliott. With me are my colleagues Corinne Amato and Stacy Greenspan, and also with the Kessler Topaz firm, Eric Zager.
Welcome.
It's nice to be here. Thank you for Your Honor's time. The lower court committed multiple legal errors in applying MFW's requirements. First, it held an independent committee can include a member who is not independent. Second, it created a new pleading requirement that plaintiff establish the conflicted committee member, McInerney in this case, infected or dominated the committee's process. Third, it applied its new requirement erroneously, holding it was not reasonably conceivable plaintiffs could prove the conflicted committee member infected or dominated the process despite acknowledging that he was the lead negotiator. Fourth, it erred by holding the 700-page proxy was not materially misleading and incomplete because material information regarding McInerney's relationship with IAC and Diller was disclosed in an amended 10-K. Unless the court has any questions, I intend to rely on our briefs as to derivative standing, defendants' re-argument of issues decided against them below, and their new MFW creep argument, which they admit was never raised below and is waived. MFW made the negotiation and approval by a wholly independent committee a prerequisite for dismissing litigation challenging a controlling stockholder transaction before discovery. A wholly independent committee was part of the balance MFW sought to create. The lower court's ruling permitting non-independent directors to be on an independent committee rebalances the scales heavily in the controlling stockholder's favor. An independent committee is a deliberative body whose members are supposed to deliberate with each other without the influence of non-independent directors. Non-independent directors will necessarily influence the committee's deliberations and may provide the controller with insight into the committee's discussions and positions on price and other terms. Non-independent directors can negatively affect the process in subtle ways that cannot be known at the pleading stage. The lower court's ruling would prevent plaintiffs from discovery into the influence of conflicted directors on the committee's process.
Is it the case that in the MFW context, there's not a single Delaware case that squarely holds that you can have a special committee with some conflicted members?
That's absolutely right, Your Honor. There is no case that holds you could have an independent committee with non-independent members. It's in the name.
Because Trade Desk and GGP didn't address that issue, even though it surfaced.
Well,
correct.
That's right, Your Honor. In GGP, MFW was not at issue. There was an analysis as to whether or not a minority stockholder was in fact the controller, which necessitated an analysis of the minority stockholders' influence on a process. In Trade Desk, the plaintiffs in that case did not argue that an entire committee needs to be independent, and the court in that case decided the issues that were before it based on the arguments that were presented, but that shouldn't change Delaware law because one plaintiff didn't make an argument. And in MFW said that the ruling was following Weinberger, Lynch, and their progeny. Weinberger used the wholly independent standard. Conn v. Lynch, Conn v. Tremont, America's Mining, Weinberger all used the formulation of an independent committee of directors, not some independent directors and some conflicted directors.
Mr. Davenport, while we're talking about this, help me understand why in the demand futility context where we look to the majority of the board being disinterested, it's a different dynamic. I get that, and that's what I'm asking you about. Why does that not transfer neatly to this context?
Well, I think it goes to the policies and the protections of who the doctrines are intended to be there for. And in the demand futility context, what we're talking about is a standard that prevents a stockholder from displacing the board as the corporate decision maker. And in that case, the court looks to whether a majority of directors are independent. MFW, the focus is on what is the process that best protects minority stockholders. And when we're looking at what's the best protection for minority stockholders, it is not a committee that includes some non-independent directors and some independent directors. An independent committee must be wholly independent to protect minority stockholders, to ensure that negotiations are conducted at arm's length by like a third-party transaction. Allowing a non-independent director to participate in the committee and negotiate on the committee's behalf is letting the fox into the henhouse. A wholly independent committee ensures the transactions are approved by independent directors. If there's a committee of 3 and the vote is 2-1, with a non-independent member voting for the transaction, there would be committee approval, but not a majority of independent director approval. And if the committee had 7 members and 3 weren't independent, those 3 members would just need to convince 1 independent member to support the transaction for there to be committee approval.
Let's stick with that hypothetical. You've expanded to a 7-member committee. I was going to do 5, but let's do 7. That's even better. And you have 1 member who lacks independence, and that 1 member is essentially, by all accounts, a potted plant that just hangs out. Under your understanding of what wholly independent means, do I have it correctly that you would say that the presence of the potted plant undermines the independence of the committee in its entirety?
Absolutely, Your Honor. And because, one, if a committee member is nothing but a potted plant, it raises questions as to why they're on the committee in the first place. But an independent committee should be able to deliberate independently without a non-independent director sitting in the room. That non-independent director would then hear all of the legal and the financial advice that the committee got and could report that back to the controlling stockholder. That non-independent committee member could ask questions or say things that have some subtle influence that doesn't show up in a proxy statement or in minutes that you really, especially at a pleading stage, you just can't know.
But we're doing the independence or lack of independence in the rear view mirror, though, aren't we? Do you understand what I mean? I mean, this is judging after the committee's been appointed, and if a board appoints people in good faith and they're later declared lacking independence by a court, it doesn't seem like a very efficient way to manage these types of processes, does it?
Well, Your Honor, I think it's a very efficient way because the message to controllers is don't put anyone on a committee who lacks independence. And while maybe, some directors may believe that someone else isn't independent, here we have, someone like...
Well, is that really practical? I mean, you have board and there's relationships among members of the board, and what you're really saying is, in some instances, you have to go outside of the company and appoint new board members in order to make this happen and make it functional, aren't you?
Well, Your Honor, I'd say that what we're focused on is what's the best protection for minority stockholders. And in MFW, the court ruled that an independent committee of directors was the best. That plus a minority stockholder vote was the transaction structure that respected scholars believed was the best process that you could have for minority stockholders. And if we're now going to start allowing one or two or three non-independent members onto the committee. That is not the best protection for minority stockholders. I'm going to turn to the infected or dominated part. The lower court erred by requiring the complaint establish that McInerney infected or dominated the committee. This new requirement imposes a fact-intensive inquiry that defeats MFW's purpose of providing a clear and narrow pathway for pleading stage dismissal of controlling stockholder transactions. The lower court's onerous pleading standard is at odds with the reasonable conceivability standard. As this court ruled in Cornerstone, conflicts of interest support a pleading stage inference of disloyalty. McInerney's lack of independence and role as lead negotiator made it reasonably conceivable he infected the committee's process. Furthermore, since committee members are inherently part of the process, pleading that a non-independent member affected the process is unnecessary. The requirement that a complaint plead facts showing a non-independent director infected or dominated the committee places an unfair and difficult burden on plaintiffs. Proxy statements are not required to give play-by-plays of who did what, who said what, and exactly when they said it. Lawyer-drafted documents like proxy statements and board or committee minutes will not contain admissions that someone infected or dominated an independent committee. Section 220 production is usually limited to formal board materials and does not include emails, text messages, or other documents which may be necessary to show infection or domination. Moreover, documents showing infection or domination may not all be in the possession of the corporation. They may be at the controller. If a conflicted member's infection or domination of a process is to be a requirement for an entire fairness claim, then discovery and a trial are absolutely required. Even if allegations of infection or domination were required, as pages 31 to 35 of our opening brief and pages 14 to 17 of our reply brief show, the complaint alleges that McInerney personally conducted negotiations with IAC and controlled the flow of information to other directors. These allegations make it reasonably conceivable he infected or dominated the committee. And I'll note, McInerney's name appeared 27 times in the background of the proxy section. The other two directors appeared twice each. And while infection or domination shouldn't be a mathematical exercise where we just count up the numbers, when it's 27 to 2, it's pretty clear who was in the game and who was on the sidelines. And McInerney was the only one in the game.
Mr. Davenport, let's just say hypothetically, the court were to agree with you on your first 2 points. You need a wholly independent committee and McInerney infected the process. Then doesn't the question really become whether this is an MFW transaction in the first place? And as you point out, the Vice Chancellor really just raised that sua sponte in a footnote. So why wouldn't it be appropriate to remand for a full consideration of that issue and have the Vice Chancellor address it and give the parties a chance to brief it?
Well, Your Honor, I think that could be one way to go. But I will say that if the argument that the defendants are making that MFW does not apply to this transaction were accepted, then the opinion below should be reversed on that basis alone. The trial court ruled on page 1 that, quote, it is undisputed that the reverse spinoff was an interested transaction in which a controller obtained a non-ratable benefit at the expense of the minority, presumptively subject to review under the exacting entire fairness standard, end quote. That ruling is consistent with Conn v. Tremont, which was not a cash-out merger case, where this court ruled that when a controller stands on both sides of the transaction, the conduct will be viewed under entire fairness. MFW provides an exception to MFW provides an exception to avoid entire fairness. If MFW does not apply to the separation, then entire fairness applies and the opinion should be reversed. Finally, touch briefly on disclosure. Defendants failed to satisfy MFW because the stockholder vote was not fully informed. The proxy's disclosures on pages 124, 125, 174, and 175 had disclosure of, quote, relationships involving significant named executives and directors, end quote, and potential conflicts of matched directors, which was partially misleading and incomplete. Having traveled down the road of partially disclosing such information, defendants were required to provide a complete and accurate description of McInerney's relationship with IAC and Dillard. The lower court ruled that although McInerney's relationship with IAC and Dillard was not disclosed in the proxy, it was mentioned in an amended 10K, which was supposedly incorporated by reference into the proxy. The proxy only referred to the amended 10K once on page 308. Defendants admit that the 3 other proxy pages that the lower court cites below did not mention the amended 10K. The proxy's passing reference to the amended 10K did not cure the proxy's failure to disclose material information concerning McInerney's relationship with IAC. The proxy didn't even tell stockholders to review the amended 10K for information about relationships between the committee and IAC. It merely listed the amended 10K with 14 other documents for where stockholders could generally find further information about IAC or Match's financial performance. A list of SEC filings is not disclosure. Stockholders are not required to pursue a scavenger hunt through a 700-plus page proxy and then go review every other document the proxy cites even once to hunt for scraps of material information.
Does it matter that there was a hyperlink? I mean, isn't that the functional equivalent of being in the document itself?
I would say no, Your Honor, because, one, any stockholder who got a paper copy of it's not clicking on a link to access it. And 2, it can't be the rule that you can provide a hyperlink to every document the company's ever filed with the SEC and deem every one of those documents incorporated by reference. And even if you are going to provide a hyperlink and say it's going to be incorporated by reference, you need to, one, tell stockholders that they should look at the document for information about conflicts, and 2, put it in the place where you otherwise discuss conflicts of interest, not at the back of the proxy when you refer to financial performance information with a list of 14 other documents. I would like to reserve the rest of my time for rebuttal.
Thank you very much.
Thank you.
Good afternoon. May it please the court. Maeve O'Connor of Delaware and Plimpton for the Match defendants. I'd like to respond to a few aspects of what my colleague just spoke about. And I want to turn first to the topic of Mr. McInerney's independence. In a decision by the lower court that was very thoughtful and thorough and nuanced, that's the one piece that we would respectfully quibble with. There are 3 aspects of plaintiff's allegations that, taken together, viewed holistically, undercut any inference of a lack of independence and make this case different from any case in which, at the pleading stage, a lack of independence has been found. First, Mr. McInerney was the chair and CEO of an entirely independent public company at the time of the merger negotiations. And this is a very key fact that strongly undercuts the inference the plaintiffs seek, separates this from any other case. He was earning compensation at Altaba comparable to what he had earned at IAC. There's no allegation that Barry Diller or IAC played any role in getting him the job. And we're not aware of any case in which an inference of beholdenness based on a prior business relationship was drawn when the person had moved on to independent and increasing professional success. And I would submit that there's no reasonable inference that a successful professional is forever owned and tainted by virtue of an earlier employment relationship. The cases that find a lack of independence based on a prior relationships all have pleaded an extra fact that gets to materiality. So, for example, the board compensation was material. I'll come back to this. The director worked their entire career and had recently retired, wasn't doing anything else for the controller. The director continued to be employed by an interested party. The director had a very close personal relationship with the interested party and the prior source of employment. And in a couple of cases, maybe the director had been designated not independent under NASDAQ or other rules. So that's a key issue that distinguishes this case. Second, the factual allegations about Mr. McInerney's wealth and his professional success undercut any inference that his past relationship with IAC was financially material to him at the time of the negotiations. And this is something that we really feel plaintiffs can't have both ways. So based on their own allegations, he left IAC in 2012 a very wealthy man. That defeats any inference that his subsequent compensation from a couple of boards that had been IAC affiliated at the time he joined them was material to him. And in addition, plaintiffs talk about a 20-year relationship. There are no well-pleaded facts that IAC continued to be affiliated with those companies at all during Mr. McInerney's board tenure. IAC spins off companies. That's the allegation, and plaintiffs haven't pled otherwise. And then third, there's no allegations of a friendship or a personal relationship of any kind here. So I think what we're left with is a situation where where you had a prior business relationship, and then you have someone who's a CEO now of a new company. He's not friends, he's not financially beholden, and there's nothing that makes that prior relationship material to him at the time of the transaction. So our view is that Mr. McInerney is in fact not reasonably pleaded to lack independence in this case. Moving on, I want to talk about the MFW committee structure question. We think that the court's holding that a majority independent committee suffices under MFW as long as the member who allegedly lacked independence didn't dominate or infect the rest of the committee is rooted in long established principles of Delaware law.
Is there a single case that holds that in the MFW context?
No, I think that Trade Desk comes close to that, but obviously the issue wasn't squarely presented. I don't think it's come up in that precise setting, but a couple of things. The business judgment rule, as this court noted in Nixon versus Blackwell, in business judgment rule cases, an essential element is the fact that there's been a business decision made by a disinterested and independent corporate decision maker. This could be a disinterested and independent majority of the board of directors.
So is it your position that a controller could put a designee on a 3-person special committee and be a potted plant? Somebody who's clearly conflicted, non-independent, and not disinterested?
No, it's not, Your Honor. I think that if the person on the committee is a dual fiduciary, that's a different situation, and that would presumably lead to a pleading stage inference of domination or the like. But
well, let's just say then it's somebody who's clearly not independent and not disinterested.
I guess the question becomes what it means by clearly. And on these points, I think that the point I would make is that the courts of Delaware have guided market participants and lawyers through very nuanced decision-making and thinking about independence and about all these factors, and I think would have the ability to continue to do so. In this instance, if you have somebody who's not independent but is not dominating, I think that consistent with all of the other aspects of Delaware law in which this comes up, that committee would be functioning fine under MFW.
I think a different way to maybe ask the question is, how do we discourage boards from manipulating the process by putting people who clearly lack independence on a board, knowing that they'll have the protection of a majority of disinterested board committee members?
Well, I guess I would say this, Your Honor. I think that that is in some ways, I would suggest, not a real world problem, because a controller doesn't have to operate under MFW. To do that creates deal risk, and I don't know why anyone would take on deal risk at the same time as creating a committee that they think creates MFW risk for them. I think people try to create a committee that will work under MFW if they're going to undertake that and subject the deal to a vote of the majority of the minority and take on the deal risk that accompanies that.
Would that risk still be in play if we bought your argument that it's okay to have a disinterested committee member?
Well, I think there's going to be factual nuance about the picture, right? So dual fiduciary on the one end versus somebody like Tom McInerney, who frankly I believe is independent, should be deemed to be independent, and was a very effective member of that committee. So I think there'll be factual nuance along the way, but I do not believe that there is a real world concern that people will put people onto a committee who are intended to undermine the functioning of that committee in order to, because they're trying to get a deal done, and they're trying to get a deal done in a way that works under MFW and gets them the protection of the business judgment rule.
But what policy sense does that make if one of the goals was under MFW is to have a pathway for pleading stage dismissal. And the other concern is the purpose of the committee is to really look out for the minority stockholders. So what sense does it make to say that you can now have that a majority of a special committee will suffice?
Well, I think, Your Honor, that it's consistent with all of Delaware law and the way Delaware law looks at the functioning of a board or a board committee. I started speaking about the business judgment rule and this court's decision in Nixon versus Blackwell, and I think the same principles that govern the business judgment inquiry at the board level also govern it at the committee level. Vice Chancellor Laster spoke about this in the Voigt versus Metcalf case, also in an article that we thought was kind of interesting that we cited at note 13 of our opening brief on appeal. I think the demand context is another situation where something that's being asked is even greater and more challenging, as this court has observed, than merely negotiating opposite someone, but rather, can we sue this person? And the case law looks at, is there a majority of disinterested and independent directors?
Aren't controller squeeze-outs different? Just a different concern versus, transactions involving executive compensation, say, where there's more deference to the board of directors.
Well, I think that arguably goes into the direction of the MFW creep argument, where the MFW was solving for the squeeze-out concerns that animated Kahn versus Lynch, a very factually specific scenario. But before Lynch, and it was the tradition that conflict transactions were reviewed under the business judgment rule if any one of the cleansing devices were used: a majority independent board, special committee of directors, or a majority vote of disinterested stockholders. So to the extent that MFW was a unique set of facts, I think that points toward the MFW creep question of whether a transaction such as this would even need to fully satisfy MFW.
But it also speaks to the protections that were part of that formulated test, does it not?
Well, let's speak about MFW, because I don't believe that MFW in any way required a fully independent committee. I don't think that's what the MFW court said. In fact, in MFW, the committee was fully independent, but there's no requirement stated in the decision that it should be. And in fact, MFW noted that the claims didn't raise a triable issue of material fact concerning the special committee members' individual independence or the special committee's collective independence. So there's nothing in MFW itself, I would submit, that requires the committee to be 100% independent. And I note that MFW described the goal of the committee as setting up a situation akin to arm's length negotiations. This court's decision in Malpede was a situation where, despite a conflicted director on a committee, the transaction was nonetheless viewed as subject to arm's length negotiations because that person didn't dominate. So I think if you trace through all these lines of cases and all these principles, you don't get, in our view, to a place where MFW was requiring a 100% independent committee. Rather, it was requiring a well-functioning committee where the independent directors were not dominated and were able to carry the vote on how the transaction would be negotiated. This is the way the law works in Delaware with regard to any type of board decision. If the majority can carry the day, and if a minority is not dominating or infecting the process, then that gets to a good result, and that is protective. And Delaware law views that as sufficiently.
If we disagree with you on Mr. McInerney's independence, what about his status as lead negotiator and having infected the process?
So I'll be happy to address that. I do not believe that the allegations show that Mr. McInerney dominated or infected the process. And if you look at the arc of negotiations described in the proxy and in the minutes, what you see is the committee meeting and discussing, and then Mr. McInerney would speak to Mr. Levin from IAC, who, by the way, used to report to Mr. McInerney. That's not a dynamic that suggests that Mr. McInerney can't handle Mr. Levin. And then there would be further discussions with the committee each time and each step of the way. But in addition, importantly, some of the domination cases look at whether the arguably conflicted committee member was selecting the advisors and controlling the flow of information. And the proxy and minutes also reflect multiple meetings just with the advisors for both sides meeting together and then reporting back to the committee and having advisor discussions. So Mr. McInerney's conversations were not the entirety of the negotiations, and they were not the sole source of information coming to the rest of the committee about the negotiations and what was happening in the negotiations.
Was he the lead negotiator?
He was the person who interacted with Mr. Levin from IAC. So in that sense, you could say yes. But the advisors were meeting and negotiating also based on instructions from the special committee as a whole, and that's reflected throughout the proxy and the documents. So it's not a situation where Mr. McInerney is going off into a closed room and coming back and announcing a deal. Bankers and lawyers are involved in the conversation. You see the proxy will say, Goldman Sachs went forth based on instruction from the special committee to negotiate X, Y, or Z. And so it's not, in our view, a situation that adds up to domination. And in addition, I think a committee has to be able to decide the best way for the committee to function and to negotiate, right? So I think a committee has to have flexibility to say, why don't you go speak to that person, and not have that automatically mean that that's domination of the other committee members. I would also add that plaintiffs' very extensive allegations about Ms. Saman's long career as a prominent M&A lawyer would kind of make unreasonable, in our view, any inference that she's being dominated. Why would that be? And I think that Mr. McInerney had a role, the advisors had a role, and it was a robust negotiation process. I see that I'm virtually out of time. I want to just see if there's one more point I would make here. So one thing to point out is that the test that the Vice Chancellor laid out leaves lots of room for thorough examination of the committee and the specific facts, and that inquiry will maintain deal risk to incentivize the committee, the independence of the committee, right? So there's plenty of room to look at what has been happening, and boards are under disclosure obligations with regard to the background of the merger and how the process went. And in that process, you could see if someone is dominating or acting inappropriately. There's lots of room for those arguments to be made. I don't think we should assume that discovery is needed because people might not abide by their fiduciary duties of full and fair disclosure in a proxy statement about a transaction.
Thank you very much.
Yeah, thank you very much.
Good afternoon, Your Honors, and may it please the Court. MFW was kind of an instant icon. It targeted a specific problem, the problem of a controller squeeze-out. Footnote 139, Vice Chancellor Zern noted that the separation here, by which the controller gave up control, the Vice Chancellor said was, quote, the opposite of the freeze-out merger that inspired MFW. So we have a situation where the case was litigated and we did not raise the MFW creep below. As if to get the business judgment rule, it was litigated on the basis that you needed both an independent committee and a majority-minority vote. If MFW did not, if the double dose that MFW required for business judgment protection in a controller squeeze-out did not apply to a transaction like this, at the very end of the spectrum from a controller squeeze-out, to say nothing of the Chancery cases that have applied and required the full double dose of MFW to controller compensation, on an annual basis, to services agreement with controllers, which are quite common, requiring that there be entire fairness review unless there's both an independent committee and a majority-minority vote. I disagree with the plaintiff's point during the opening argument that if MFW does not apply to this case, that it must be reversed. I submit just the opposite. It must be affirmed. Because then the McInerney issue and the majority independent committee issue goes away, And if the court were to find that the proxy statement was adequate and that there was therefore a majority-minority vote of the stockholders, then under the tradition that existed before Lynch, after Lynch, and before MFW, that any one of the three cleansing devices, majority independent board, special committee, or stockholder vote, was enough to get to business judgment, then you could affirm the court should affirm simply on that basis. MFW never itself intimated that the double dose committee plus majority-minority vote was required for all controller conflicts. It dealt with the specific problems of controller squeeze-out, which is at one far end of the spectrum. Lineage, we submit, is extremely important.
Why shouldn't that issue be remanded? Because your friends say, you know, it was brought up sua sponte and this court hasn't reviewed those cases, and why shouldn't the parties have a fair chance to brief the issue and have the Vice Chancellor address it squarely?
Yeah. I think my answer is not going to be as good as the question. I think that MFW has been fully briefed now before this court. It's a legal issue that can be decided with this court's special expertise in why MFW rethought Kahn versus Lynch. A remand on the question sort of bleeds into the question of why was it not raised below? And that's really the question that I submit in all candor is better than any answer I can give. There is now, and has been in several cases led by Vice Chancellor Lasser's opinion in Easy Corp. I don't know if it's a wall of authority, but a significant number of Chancery Court cases have endorsed what the Chancellor referred to below, the Vice Chancellor referred to below as MFW creep. We think those cases are wrong. Certainly in a case like this one, which is, as I've said, the polar opposite of a controller squeeze out.
Thank you very much.
Thank you, Your Honors.
I'll start with the argument about MFW creep was not raised below, and it's waived. The interests of justice are not served by allowing sophisticated parties and their lawyers a redo on their litigation strategy. The point that this transaction, there really was no response to my citation of the Vice Chancellor's ruling that entire fairness applies to this transaction because it is a merger with a controlling stockholder in which the controlling stockholder extracted benefits at the expense of the minority. And so for those reasons, the argument should be rejected. I want to turn to my friend's argument that McInerney was not, that he was disinterested and independent. The lower court correctly determined it was reasonably conceivable that plaintiffs could prove McInerney was not disinterested and independent of IAC. He had a 20-plus year relationship with IAC and Diller that included stints as IAC's chief financial officer. He was the CEO of IAC's retail division. He was the CFO of IAC's Ticketmaster affiliate, and he served on the boards of ILG, HSN, and Match. My friend said that Mr. McInerney left IAC a wealthy man. That's right. IAC and Diller made him a very wealthy man. He made over $58 million working for IAC. I'd also note, as we put in paragraph 68 of our complaint, when Mr. McInerney departed IAC, he said that he was more than grateful to Barry Diller for the opportunities he and IAC had given me. While Mr. Diller said that he wished that he could stand in Mr. McInerney's way, he said no one has played a fuller role than Tom in contributing to the sustained growth of IAC. It is at least reasonably conceivable that plaintiffs prove that Mr. McInerney was not disinterested and independent. Turning to the independent committee requirement, One, I want to note, in MFW, my friend's right, the committee was entirely independent. It was a committee of 3 people. And the vice chancellor in the MFW ruling noted that the committee was comprised entirely of independent directors. And both the Chancery Court and the Supreme Court noted that that committee initially consisted of 4 members. One of those members stepped off because he was potentially not independent. So that was something that the court called out as at least important enough to be mentioned in the opinion. So next, Your Honor asked a question about whether we should be discouraging controlling stockholders from putting conflicted members on the board. If the court does not reverse, the opposite is going to happen. Controllers are going to be encouraged to put conflicted members on committees because a controller would rather have a potted plant in the room than no one in the room. And there are ways that the controller could put committee members on there that would influence the process. Controllers don't need any more help. They dictate the timing, initiation, and structure of transactions. They get to pick who's on the board. They get to pick when the transaction, the structure of the transaction. They can reject the transaction. They can decide whether a minority stockholder vote applies to the transaction. They can decide whether a special committee will be in place. And if there is a special committee that's in place, the directors they put on the board get to pick it. Controlling stockholders are doing just fine. They don't need any help any further protections. It's the minority stockholders who need protection from this court to tell controllers they can't put conflicted members on the board. And now we've heard for the first time today that, well, maybe if there's a dual fiduciary, that would be too far. But if there's just someone who's not disinterested in independence solely because they made $58 million working for IAC as chief financial officers, that's okay. They can stay on the committee. It's just the dual fiduciaries. I think that really does favor in more of a bright line rule that controllers can't put conflicted members on independent committees. And it's just not something that at the pleading stage is something that the court can really determine, because we've heard that Mr. McInerney didn't, I guess there was an admission that he was the lead negotiator. The fact of the matter is there were 7 calls that McInerney led that were described in the proxy. That's the proxy. We haven't had discovery. We don't know how many calls there are or what other influence he had. We just know that the other 2 members were not active in the process, and it was McInerney who was leading. See that I'm just about to turn red, so thank you.
Thank you very much, counsel. We appreciate the arguments. We'll take the matter under advisement. Please recess the court.
Please rise. Hear ye, hear ye, hear ye. All manner of persons having anything before the Supreme Court of the State of Delaware may now depart and give their attendance to the call of the court. Court is now adjourned. God save the state and the honorable court.